I'm Larry McGee, Managing Broker of the Berkshire Group. This is the first in a series of 6 videos discussing the exclusive right to buy listing contract used in the state of Colorado. Before we get into this, let me just say that these videos are for the exclusive use of the agents licensed with the Berkshire Group. If anyone views these and takes information from them, you're certainly welcome to it. However, the advice here is that you consult your managing broker before you complete any contracts and the advice provided by these videos. With that said, we'll just get into this and we'll get moving. First off, right at the top is our logo, the Berkshire Group. My name in this case, this is set up in such a way that it will be customized to the agent inside the company. Note there's a spell check device. I would encourage you to use that before you complete the document and work through that. Just make sure you've spelled things properly. We've also got a couple of save buttons. I would suggest that from time to time you save the document as you're working with it. Things do happen with computers and it's difficult sometimes to go back and recreate. The normal disclaimer at the top: the printed portions except differentiated editions have been approved by the Real Estate Commission. This is mandatory January 2014, so this is the current. We're in the editing section, which means we can do things inside the contract, fill in the blanks, etc. This new box, the Contract Advisor, we'll check into this as we get into the document further, but this provides some background information for some of the blank spots in the contract. Note this is a binding contract. The form has important legal consequences. Parties should consult legal and tax or other counsel before signing. Compensation charged by brokerage firms is not set by law, established by each real estate brokerage firm, and different brokerage relationships are available, which include buyer agency, seller agency, or transaction brokerage. This particular contract is the exclusive right to buy listing contract, what we used to call the agency contract. This establishes the agency relationship between the agent, the licensee, and the consumer. We have 2 different options here. One's buyer agency, the other brokerage. The management philosophy of the Berkshire Group is that we generally conduct our business as buyer agents. So I've checked that radio dial, and we have today's date, the 9th of March. First section is the agreement. Buyer and brokerage firm enter into this exclusive irrevocable contract, buyer listing contract, and agree to its provisions. Broker, on behalf of the brokerage firm, agrees to provide brokerage services to buyer. Brokerage firm will receive compensation as set forth in the buyer listing contract. What this means is that the broker, in this case it would be me, working on behalf of my own firm. The contract is with the consumer and the firm. It is initiated and completed by the agent or the associate broker. Payment goes to the brokerage firm and is then distributed by agreement to its associate brokers. Note over here we have this little question mark. I'm going to check this little question mark just so we get into this exclusive right to buy listing contract, this Contract Advisor area. Buyer listing contract is in defined terms, so you may use and capitalize the term buyer listing contract as needed, as opposed to typing out exclusive right to sell. In other words, we've got a shortened a way to say that. The broker will provide services on behalf of the firm and will be paid. Each section of the contract defines terms so that you may refer back to a subject clearly and precisely. These red inserts here are what you can expect to find with the Contract Advisor. If you feel that there's some valuable information there, don't hesitate to go look if you have any questions. I'll click out of that for now. Again, broker and brokerage firm. Well, the Berkshire Group is a multiple firm, so we're going to check this radio dial. And we've already inserted the names of our buyers here because I had created a previous contract to sell their property, a listing property contract. So I've inserted their names, Joseph Blow and Mary Blow, And when I clicked in the CTME contracts, I just opened up their account and their names flowed right into this. We could also pull them from the client database by clicking here. We have a variety of clients we can scroll down that I've worked with in the past. I would suggest that whenever you add new people, you go ahead and add or update the client database. We don't need to do that in this case because we've already done it. Add or update the client database, click here, or click client first, company, and second is one client. You can click that, or you can enter company name, and this is going to give you a company name or trust name. We often do trusts. In this case, we might want to have the Joseph and Joseph Blow and Mary Blow Living Trust as an example. We don't have to do that certainly, but some people want to purchase properties as a trust, or certainly in a company name we would do that. We're just going to check that off today because we're just dealing with Joe and Mary as a couple. And I'm going to click off remove company name, and the screen reverts back to a normal contract. Note that there's room here to add other buyers. Oftentimes we'll do joint tenancy and we'll have multiple buyers, or even tenants in common and have a variety of buyers. We can certainly add more buyers by clicking here. Most cases we're probably going to be dealing with two buyers or one buyer. The brokerage firm in 3.2 is noted as the Berkshire Group. The broker's Larry McGee. We can add co-broker agents by saving this contract if we wish to add a co-broker. Property means real estate which substantially meets the following requirements or similar real estate acceptable to buyer. And there's a place here for clauses. Now, we'll come back to clauses later on. There's really not a lot of clauses that are going to apply here. We're really just going to put in some description that says two-story home in the Cherry Creek School District. Priced below $500,000. Now, there's various arguments about just how specific you want to maintain or create this area here, because the normal consumer oftentimes will change what they're thinking about. I created a dollar amount. I don't know that you should or shouldn't do that. It depends on the comfort zone of your client. The reality is, if the client says, I'm willing to pay $525,000 for a house, that's probably close enough to similar real estate acceptable to buyer. I sit here and put in two-story. So two-story in the Cherry Creek School District, two-story DETACH detached dwelling in the Cherry Creek School District. So we can play with that. We can remove this and just make it. And of course, the next day the client says they want to live in a different school district. Nothing right or wrong about that. You don't want to over-define that to some very narrowly focused property because you may have a difficult time finding that. Purchase or lease. If this box is checked, we're going to negotiate a lease. We don't contemplate that in this particular contract. The listing period begins March the 9th and continues through some date, and I generally put in 60 days or less on a buyer listing contract. Whoops, that was too short. I need to be at May the 9th, and I'll probably go to the May the 12th to go over the weekend. Generally speaking, if we have people who are ready, willing, and able to purchase a house, which is when you would create this contract, we're going to get this job done relatively soon. There may be reasons why you have a longer listing period, even up to a year. If you had a relocation person that was going to be in and out of town every other month for the next 6 or 7 months before they purchased, but they wanted to look at homes, you may want to create a long-term listing contract. But generally speaking, we want to keep them relatively short. We can certainly amend the contract and extend it if necessary. Applicability of terms, NA, or the word deleted means not applicable. And down at the bottom of this contract, we'll talk about making sure that we don't use NA. The abbreviation MEC, mutual execution, means the date upon which both parties have signed. So the day as used means the entire day ending at 11:59 p.m. I would suggest that you be real careful that you don't end up trying to negotiate things that late in the evening. Try and set your deadlines much earlier in the day. Quotation of dates and deadlines. For instance, if it's on the last day, it's 3 days after MEC. Normally, I'm going to check on Saturdays, Sundays, and holidays. I'm going to check will. There's some arguments from various attorneys that says will not. That seems to be sort of a split vote. I generally think will is just fine. Brokerage relationship. This is defining the relationship between the agent and the consumer, and we're representing the buyer as a buyer's limited agent. In-company transaction with different brokers. This may occur if we have a property that's listed inside the brokerage itself that this particular client would like to buy. Because it's a different broker, even though it's inside the company, we can have agency relationships with both of our clients. In-company transaction, one broker, when that occurs, let's say, for example, I had a listing, a property for sale that this buyer wanted to purchase. Perhaps we would have to consider that we have a buyer's agency situation. We're going to have to, if I have a seller agency with the seller, we may have to go down here in 4.3.12 and check this box. A buyer agency unless brokerage relationship was with both. And I would encourage you to sign that on the off chance it happens. If this box is checked, broker represents buyer and must treat seller as customer. Unless broker currently has or enters into an agency or transaction, in which case broker must act as a transaction broker. What this box does, or this paragraph does, is basically takes both parties. If you have been representing both parties, it takes both parties back into a transaction broker, a more neutral position where we're not advocating for the rights of our consumers at that point. They're no longer clients, they're consumers. All right, well, that concludes section 1 through 4. We'll come back in the next video with section 5. Any comments, certainly shoot your questions my way, and I appreciate your time. Thank you.